Good day, I'm Dennis Marais, Legal Advisor, SEESA Labour.
Good day, I'm Nhlanhla Tshabangu, Legal Advisor, SEESA Labour.
Nhlanhla, thanks for being here. I think it's important today to let the people out there understand more about the topic that's up for discussion. Can you please give us the introduction of the topic? What are we discussing here today, so that all the people looking at this video are well informed and know the ins and outs?
Okay. Well, today we're going to be talking about union members. Okay, so basically employers normally, they come through, they have their own employees, and then all of a sudden they've got union members. So the next question is, if you do get union members, what do you do? But specifically today we'll be talking about what if those members actually decrease. So if they go down in size, what exactly must the employer do? So basically, yeah, that's the topic we're going to be discussing today.
Okay, thanks. I think just to make it more practical, from my side, I'll ask a few questions what most employers are facing on a day-to-day basis, and then you can maybe give us some answers on, based on the Labour Relations Act, what is important to take note of when facing that situation.
Yeah.
Is that fine with you?
No, that's fine.
Okay, great. Okay, for example, I'm the employer. I've got 15 employees that are members in the workplace of a union. And my employees approach me, they tell me 6 of them are resigning from the union. I just want to know from your side, what is your take on that? What should the employer be informed of, and what is the steps that should be taken, the necessary steps obviously to avoid frustrations, and the most practical version of handling a situation like that?
Okay. Well, first and foremost, if they do come and they say, listen, I'm tired of this union, I've resigned from it, then basically the first thing you must do is then make sure that you've got documentation confirming that they've actually resigned from that union. And
okay.
Then once you've actually done that, then it's a numbers game. You basically need to now find out, are they still within the majority, or now are they in the minority? Okay?
Just on that point, if you say to find out if they're majority minority, can you just explain to us how do I determine if they are minority or when they are majority?
Okay, so basically I'll start with minority. Now minority, basically looking at it, it doesn't really specify in the CCMA, but would say about 28 to 30%, but let's just say about 30% of your workforce. So if 30% of your workforce joins the union, right, so they'll be seen as minority, that being sufficient. So what that means, they're entitled to 2 rights. So there'll be 2 rights there. That's one of them is access to the workplace, okay? Meaning that the union has access to the workplace, they can canvass and get more members. And secondly, the other one is deduction of the union levies and subscriptions. Now, the employer will ask after that, what does that actually mean? So practically, what they do is they give you the form, which authorizes you, the employer, to deduct from their salary and pay the union levies and subscriptions. So basically, once you have that form, then you are authorized to actually do that as an employer. Because employers always say, okay, how can I just deduct without any authorization? That actual form itself is the authorization that you need. So that's the sufficient minority one. Okay. And then the majority one now, that's when now there's 50% or 50% plus 1 of your workforce is now part of the union. Now there you still have the first 2 rights which I've mentioned, but now you have an additional rights. Now those additional rights would be, so number 1, they can have union representation. So meaning they can elect a shop steward if they have a shop steward there. And secondly, they can basically have access to information, so they can ask employers to supply them with certain information that they require. Okay. And then they can also have access to union activities. Now, just to describe those 3 points. So the union activities one is linked, for example, with the representation one. So meaning that if they elect a shop steward, right, they will inform you who's the shop steward. And then from there, the shop steward might have basically activities that they have to do with the union. So training, for example. So there's certain days that they might require to get that training. And then if we go on to now to, so I've talked about the access to information, I've talked about the representation, and I've also now highlighted basically what it means to basically have those union activities. So that would be now the majority side. So then once you've basically figured out, is it still sufficient or majority, then you know what is the next step.
Okay, great. Thanks for that. As an employer, like I said, if I've got 15 members that are unionized, they are members of the union, and 6 of them resign. Just to explain, if you can just explain to us, do they still then, are they still allowed to have 2 shops to it? Or can I give them notice to then withdraw 1 shop to it?
Okay, so basically now it's a numbers game, so it goes practically now. So basically speaking, when we go on the majority, so if they're no longer 50%, 50% plus 1. So once that number falls down, that means that the rights that they enjoyed before, they no longer have. So let's say, for example, they had 2 shop stewards before, it might mean that now they have 1 shop steward, or they don't even have shop stewards at all. So what I mean there is, for example, if I had rights before to have union representation because I had 50 plus 1, and now I no longer have 50 plus 1, I'm now on the 30% situation. That means that the rights that I had to have shop stewards now fall away, or they're now limited to, instead of 2, it now becomes 1, for example. So when I say 2, it's like you're saying 15, 16. So if you have 50 or more, so for every 50 employees that you have, for example, it might mean that they're entitled to have 1 shop steward each. So you might end up, yeah, exactly. So you might have more than 1 or 2. But in your scenario, that 1 might actually disappear to no longer being 1. So basically, to answer your question there, that's what it means, yes.
100%, I understand that. And then just another question, if the employer and the union do not agree about the resignation of the additional shop steward or certain rights of the organizational rights that they're entitled to, or what they might lose, what are the rights of the employer and the union then if they don't agree? I know the Labour Relations Act speaks about a dispute that can be referred. Can you just elaborate on that and explain to us what both parties can do there?
Okay, so basically, as I stated, if they do come and say, listen, the numbers have gone down. So I'll start with the scenario where now they're no longer majority, but they've gone down, but they're still minority. So in that scenario, they still have now minority rights, they no longer have majority rights. But now, let's say they lose so many members that they no longer have minority rights. So what do you do next as an employer? So there, what you do, you must first establish if there's a recognition agreement in place, and if there's no recognition agreement in place. So what that means is, if there's one in place, then the recognition agreement states that basically, if the numbers go down to such a point, the employer must inform the union, listen, your numbers have gone down, I'm giving you, say, 30 days to rectify. If the numbers are not rectified by then basically we'll then give you another notice that we're going to terminate the recognition agreement. But if there's no recognition agreement in place, the law states you must give them reasonable time. So reasonable time is basically about 30 days as well. So you would inform them, listen, your numbers have gone down, same procedure. If you do not rectify it, then basically we'll then notify you that the actual agreement between both parties comes to an end. And then the most important part now, you know, the union might say, listen, we still believe we have our rights, we still have our members. So if there is a dispute now between the organizational rights, basically, what happens here is that the matter is then referred to the CCMA.
I see.
But if the matter is referred to the CCMA, then basically the commissioner will be the one elected to basically decide which on both parties, what is the decision? Do they still have the rights or they don't have the rights as well? So in this scenario as an employer, I know employers will be panicking thinking, okay, CCMA, what do I do? We definitely advise that you do seek legal representation to actually assist you with that matter, and you get people that are specialized to do that, to assist you there, because it can get pretty difficult when it comes to the CCMA.
Frustrating, I assume.
Yes, yeah, yes, definitely.
Okay, well, I think that is the topic that we discussed today, and hopefully it was very informative for the people out there. So that's what we have time for today. please seek professional legal advice. Don't handle the matter just on your own. You're just going to frustrate yourself, and at the end of the day, make incorrect decisions.
Okay, right. If you have any other further questions or information that you require, please go to the website, SEESA website, and then basically we will assist you further there. Thank you.
Thanks.